Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. And tonight's lecture is going to cover offenses against public morality. Now, let me lay the foundation here before I get started on this. Please understand that different people have different levels of what they deem to be moral or not moral. And we're not here this evening in this lecture to debate that fact. We're here to talk about the law and the history of law as it relates to public morality and how things may have been and how things have kind of changed. So parts of the discussion we'll talk about crimes against public decency and morality. We'll look a little bit at prostitution, pornography, what is considered to be obscene or lewd, or at least in history, what was considered to be that, and how it's evolved over the years. And we'll look at things like gambling and a little bit of controlled substances, and then possibly, if we have time, a critique of laws that regulate public morality. So that's kind of where we're going to go this evening. So let's just go ahead and jump right in. So by way of introduction, in 2013, the San Francisco, California Board of Supervisors enacted an ordinance prohibiting nudity in public places, including places like parks or sidewalks or transit stations and even vehicles. Parades and festivals, however, were exempt from that particular law. Now, at that time, nudity was defined by the board as exposure of the genitals and the buttocks regions of the body, and the law didn't include the breasts, and it didn't apply to kids. So the first and second convictions under this law were punished with small fines, but the third and subsequent violations rose to the level of misdemeanors, punished with much higher fines and the possibility of jail time. But in San Francisco, where public nudity is more common than in most, if not all, the United States, it wasn't very well received by several members of the public, including one group of plaintiffs who sued to have the law reviewed under the First Amendment. And we all know about the First Amendment. It's not just the freedom of speech, but it kind of bleeds into expression as well. Now, one of those plaintiffs, by the last name of Taub, contended that nudity is an integral part of her political speech. And she is so committed to the idea that she produces a television program on nude activism, including but not limited to nudity in public places. Now, another plaintiff by the name of Mitch Hightower sponsors an annual, what they call Nude In. And a third to join the lawsuit, George Davis, ran for elected office as the, quote, nude candidate. And he campaigned and debated while fully naked. So in 2014, U.S. District Judge Edward Chen ruled that nudity is not in itself expressive conduct that is prohibited, or I'm sorry, that is protected by the First Amendment, and upheld the ordinance. The ordinance narrowly crafted definition of nudity and its limited reach. It applied to public locations, but it didn't include all public locations like parades or privately owned businesses open to the public, contributed to Chen's decision. So public nudity is an example of a crime against public morality. And in this category of crimes, no person or property is physically harmed, and no governmental intrusion is threatened. because there is no physical harm and threat to the administration of government, and because ideas about morality are evolving, particularly as the United States has become more pluralistic, if you will, this category of crime is becoming a little more suspect, if you will. And crimes against public morality often implicate First Amendment speech and association, due process, equal protection, and other constitutionally protected rights. So this lecture is going to basically touch on some of those crimes against public morality. So, although most crimes have specific and identifiable individual victims, some crimes do not. Now, I'm going to stop right there because in a minute, I'm going to talk about this thing called a victimless crime. And in a broader sense, I want you to understand that some offenses, while they don't have direct victims, if you will, there's going to be indirect or associated consequences. So in my personal Tony opinion, really quick, there really isn't a crime that's victimless. Even prostitutes could be victims of drug abuse, or even though they got into it themselves, or pimping or pandering or other sections that we're going to look at. And some of these folks that use drugs, while it might seem victimless, they're going to steal from other people, and they're going to ruin relationships and all these other things. So I just wanted to throw that out, that yes, there's going to be a definition that talks about a victimless crime, which is an offense committed against social values and interest represented in and protected by the criminal law, in which parties to the offense willingly participate. That's what they mean. They willingly participate. It really doesn't mean in a broader sense that there's no other victims out there. So let me kind of clear that up, but here we go. Let me get back to that. So, although most crimes have specific and identifiable individual victims, some do not. And such offenses fall into a category of social order offenses called crimes against public decency and morality. Now, legal strictures against behavior that negatively affect public decency and morality originated way back in medieval times, when secular rules and church leaders became concerned with institutionalizing accepted notions of, let's say, good and evil, and especially with controlling human sexual behavior to have it conform with existing notions of propriety. And at that time, authorities were mostly concerned with crimes of adultery and prostitution. Morals offenses, as in the example that opened this particular lecture, are often identified by municipal codes, although many have also been codified in state statutes. So these crimes against public decency and morality, again, they're sometimes referred to as victimless crimes by virtue of the fact, okay, that they generally involve willing participants. Not that there's other people that are impacted out there by what's going on, but these are generally folks that are willing participants to a certain degree, if you understand what I mean. And again, these often involve people who give consent, prostitution, drug purchases, drug sales, and gambling and things like that. So the key understanding of the meaning of the term victimless crimes is to recognize that although the behavior of those involved in such crimes may violate criminal law, it is in most cases consensual behavior that is freely engaged in by all of the parties involved. And persons committing the act of prostitution, for example, are often willing, even eager participants of the crime. And the same is true for those participating in drug sales or drug purchases, or, like I said, drug use or gambling, and so on. So hence we can define a victimless crime as an offense committed against the social values and interest represented in and protected by the criminal law, and in which parties to this offense willingly participate. So in short, victimless crimes are those with willing participants. So crimes against public decency and morality typically include not only prostitution, drug use, and gambling, but also things like pornography, obscenity, and various other consensual sex offenses such as deviant sexual relations, lewdness, indecency, seduction, fornication, adultery, and bigamy. And these are all terms that you should make sure that you look at so you understand the meaning. And you'll find these throughout the chapter in your textbook. And again, a reminder, you'll find them at the end of the chapter. And although they do not have, again, readily identifiable complaining victims, it is important to recognize that those who are not directly involved in such offenses may still see themselves as victimized by the activity. So if you have a bunch of drug sales going on in your neighborhood and kids can't go outside and play, there's still, and you know that sometimes drug dealers might carry firearms and they could be gang related and all these other things. You could see how someone could see themselves as victimized by the activity while they may not be directly impacted by it, if that makes any sense. So let's talk a little bit let's focus in on a couple areas here. So let's start with prostitution. Now in July 1995, English movie star Hugh Grant was arrested in Hollywood, California for felonious activity with a prostitute, Divine Brown. Now, while some of Grant's fans asked, why would he do such a thing? Some others kind of said, well, why not? And 3 weeks later, when Grant made an appearance on The Tonight Show, female fans lined the streets with signs that said basically, "We forgive you, Hugh." So just in that little example, you can see that there are different thoughts on things like this. You have, again, those that said, hey, he's got money, he's a movie star, it's this, why would he do that? And the others are kind of saying, well, heck, why not? So a couple of different points. Now, prostitution is sometimes said to be the world's oldest profession. In early England, it was basically an ecclesiastical crime, one coming under, let's say, church jurisdiction rather than the regular courts, and not a common law offense. Now, in the American colonies, the Protestant ethic greatly influenced criminal law as it developed and quickly led to a definition of prostitution as a criminal offense. Now today, prostitution is a crime in all states except Nevada, where counties with a population of less than 400,000 are empowered to license basically houses of prostitution. And several counties have elected to license brothels. Where allowed, Nevada has a comprehensive regulatory scheme that includes zoning and licensing of these houses of prostitution, monthly testing of prostitutes for things like HIV or other sexually transmitted disease, mandatory condom use, and prostitution house owner liability for the transmission of diseases by prostitutes that have known to have tested positive. Now, unlicensed prostitution is a misdemeanor in Nevada. So again, some places have it and some don't, and Nevada is typically one of those places that we know of today to where certain counties make this actually legal. So an offer to perform the act or consent to do so is sufficient to constitute prostitution. Soliciting prostitution is the act of asking, enticing, or requesting another to commit the crime of prostitution. Now, in most situations, of course, voluntary sexual intercourse between consenting adults is not a crime. It is primarily the act of solicitation and the payment for sexual services that is the violation of criminal law. So, generally speaking, the elements of the crime of prostitution are engaging in or offering to perform a sexual act for hire. Now, you might have some different elements, again, from different states, but that's kind of generally speaking. Now, prostitution can be of either gender, and in most states, both the prostitute and his or her customer can be found guilty of prostitution. So either one. Now, there's a term out there called promoting prostitution. So the crime of promoting prostitution is a statutory offense in almost all jurisdictions. It is intended to punish those who profit or attempt to profit by using others to engage in prostitution. And generally, the following acts constitute the crime of promoting prostitution. So let's walk through those. Owning, controlling, managing, supervising, or otherwise keeping a house of prostitution. Procuring, meaning like obtaining or getting, a person for a house of prostitution. Encouraging, inducing, or otherwise purposely causing another to become or remain a prostitute, or soliciting a person to patronize, visit, pay a prostitute. Procuring a prostitute for someone else, so for another, or transporting a person with the purpose of promoting that person's involvement in prostitution. Now, other offenses are associated with the crime of prostitution. A person who has or exercises control over the use of any place that offers seclusion or shelter for the practice of prostitution commits an offense known as keeping a place of prostitution. And under common law, a place of prostitution was early on known as what they called a bawdy house, and that's B-A-W-D-Y. And the term is still used in some states today. Now, both the owner and the keeper of a bawdy house were guilty of a misdemeanor under common law. And then there's a couple of other phrases out there that I wanted to kind of run past you to make sure that you knew the definition. Pimping, this is aiding, abetting, counseling, or commanding another in the commission of prostitution or the act of procuring a prostitute for another. Pandering is soliciting a person to perform an act of prostitution. And I think I have another one. Pornography. I'll get to that in a minute. Let me give you the definition of pimping really quick. It's aiding, abetting, counseling, commanding another in the commission of prostitution. So I think we've gone through all of the definitions. Well, what about obscenities like pornography or lewdness or things like that? So a couple of definitions before we jump into this particular portion. So pornography is the depiction of sexual behavior in such a way as to excite the viewer sexually, and an obscenity is often called extreme pornography. So the word obscenity comes from the Latin word canium, and it actually means filth. And the word pornography is taken from the Greek word porn, which actually means prostitute. And all jurisdictions have laws that punish the sale, possession, and distribution of obscene material, and most have statutes defining the lewdness or public indecency. And again, I talked about the couple of definitions. Pornography is defined as the depiction of sexual behavior in such a way as to excite the viewer. And, however, obscenity is a little bit more difficult to define. A simple definition is that it's basically extreme pornography. But the distinction between protected speech and obscenity can be kind of confusing and confounding. A Supreme Court Justice, Potter Stewart, famously quipped in the 1964 decision Jacobellis versus Ohio, said this: I shall not today attempt to further to define the kinds of material I understand to be embraced within that shorthand description. And perhaps I could never succeed in intelligently doing so. But I know it when I see it. And the motion picture involved in this case is not that. So being able to define what obscene things are, or obscenity or lewdness, is difficult because of the First Amendment, and because socially, things that are socially accepted among people are different. Now, the Supreme Court resolved some ambiguity in the 1973 case of Miller versus California, and the Miller definition of obscenity is pretty much kind of what we use today. So I have a link to the Miller case, and you can go there and look at it on a website, but I'm going to kind of go through a little bit of it. So the Miller case defines obscenity as follows: the average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient or unwholesome interest. And let me define prurient a little bit further for you. This is a morbid interest in sex, an obsession with what they would call lascivious and immoral matters. So that's unwholesome, but it's a little bit more than that. So let's continue with point number 2 under the Miller test. The work depicts or describes in a patently way sexual conduct specifically defined by the applicable statute. And the last part, the work taken as a whole lacks serious literary, artistic, political, or scientific value. And I've also included here a video that you can watch about the Miller test. So we're not going to have time to get there, but I'll explain a little bit further for you. So the Miller test requires that the application, again, of community standards, thereby opening the door to differing definitions of obscenity in the United States. This element of the test has been challenged by the internet, which is both the largest source of pornography, and in combination, these characteristics are contributing to the development of basically national standards of decency. Courts continue to wrestle with the question of whether internet content should be evaluated by the standards of every community where the material is viewed, or only by the standards of the home jurisdiction of the source. So the Miller test doesn't draw a bright line between what is obscene and what is not. Indeed, the community standard provision makes it impossible to give definite examples of obscenity. And no doubt the standard is shifting in part because technology has created a landscape war where pornography is kind of vague, if you will. And prosecutors no longer have the time to prosecute dirty pictures when there are so many cases of genuine child pornography and extreme sexual violence to pursue. Now, consequently, the types of material that would likely be found obscene today are depictions of things like, let's say, bestiality or rape. But exceptions to these examples can be, easily imagined. So, for example, photographs or reenactments of rape in a documentary about rape, let's say, could be of some type of educational value, I suppose. So again, there's all of these kind of vague areas. So whether the Miller test continues to make sense in the digital era has been subject of considerable debate for years. And at the time the Miller test was handed down, pornography was printed and sent through the mail, if you will, or shown at theaters and sold pretty much in adult bookstores. Now, today, the internet is the most prevalent source of pornography, and it really is available to anyone. Now, the language in the model penal code requires a trial judge to dismiss a case where the court is not satisfied that the material is obscene. And a couple of points to be made under that. This is an additional safeguard beyond a jury finding that the relevant statute has been violated, and it's intended to protect free speech. So let's move into another area of obscenity, and we'll talk briefly about child pornography. Now, this is the depiction of sexual behavior involving involving children. And this is one special area of recent concern in pornography legislation. So in 1982, in the case of New York versus Ferber, the U.S. Supreme Court held that a New York law against the distribution of child pornography was valid, even though the material in question didn't appeal to the prurient interest of the average person and was not displayed in what could be regarded as a patently offensive manner. Stated another way, child pornography may be regulated even if it doesn't rise to the level of obscenity. So this is, something that's becoming a big issue in law enforcement, and the advent of the internet has only made this a lot more difficult for law enforcement to pursue. We talked about how an emerging area of concern is the availability of pornography on the internet, and I want you to take a moment to, you can go to this link, and I want you to look at a very brief case study, the case study of Morgan Lacan. You'll find this extremely disturbing. While there are some areas that are a little bit funny because it's part of a TV show, I think you'll understand where I'm coming from when I'm talking about how the internet makes things a lot more difficult for law enforcement. So, similar to laws against pornography and obscenity are strictures against lewdness. And lewdness is basically obscene behavior. whereas pornography refers to something that is obscene, lewdness refers to behavior that is obscene. And lewd behavior consists of intimate activity by a single individual where such activity is intended to be sexually arousing. Now, a lewd act might be captured on videotape, causing the tape to be classified as pornography. New Jersey law defines lewd acts to include the exposing of the genitals for the purpose of arousing or gratifying the sexual desire of the actor or of any other person. Under common law, it was a misdemeanor for persons to intentionally expose their private parts in a public place. Now, most of today's laws follow this particular tradition. And lewd behavior is also sometimes termed lascivious. And lascivious refers to something that is obscene or lewd that tends to cause lust. And lewd and lascivious conduct, which you probably heard that phrase before, is sometimes also termed public indecency, or what we kind of know of as indecent exposure. So, public indecency is when a person performs an act or sexual intercourse, a lewd exposure of sexual organs, a lewd appearance in a state of partial or complete nudity, or a lewd caress or indecent fondling of the body of another person. Now, Georgia law has a different example, and I'll let you look at that in there. I'll stick with this particular one. Now, nude dancing, however, has been the subject of considerable litigation because it presents a conflict between the police power of the states and local government and an individual's First Amendment free speech rights. Now, there's a capstone case in your book, City of Erie versus Paps, AM, whether nude dancing is protected expression under the First Amendment, and again, that's been the subject of Supreme Court review, and it might be good for you to take a look at that as well. Now, a couple of other terms that come up when we're talking about other consensual offenses would be things like fornication or adultery. Now, even though they may strike anyone with modern sensibility as kind of strange and really outdated, laws against what we call fornication and adultery, they do continue to exist in some states, very few. And although these laws are rarely enforced, an attorney in Virginia recently found himself accused of adultery by his lover. He was prosecuted, convicted, and sentenced through a plea bargain to community service. So, fornication is the voluntary sexual intercourse between two people, one of whom is unmarried. And adultery is sexual intercourse between a male and a female, at least one of whom is married to someone else. So, for example, contemporary Georgia law says an unmarried person commits the offense of fornication when he voluntarily has sexual intercourse with another person, and upon conviction thereof shall be punished as a misdemeanor. So, some interesting thing. We think that these are quite old-fashioned, and again, only a couple of states have these. But there's a couple of examples where things are still around. Okay, and then one other consensual sexual offense would be what they call maybe crimes against nature. And again, a lot of these terms are old-fashioned, and things have kind of changed over the years. And there's one particular case that changes here, which is why I want to cover this. So homosexuality has been traditionally viewed as what we would call, or what they called back then, unnatural sexual behavior. And it was frequently termed a crime against nature. And that was one, you don't have to like the term, but that's how the term was phrased quite some time ago. Now, where statutory interpretations are lacking, courts have generally offered their own definitions of crime against nature. Now, in a specific case, Lawrence versus Texas, the U.S. Supreme Court struck down a Texas same-sex sodomy law on due process grounds and kind of pushed aside earlier rulings. And the case banned homosexual sodomy, but not sodomy between heterosexuals. And therefore, many felt that the court would invalidate the Texas law on the basis of constitutional guarantees of equality, right? The Lawrence decision effectively struck down all anti-sodomy laws except those involving force or victimized individuals who, by reason of age or impairment, are not able to give effective legal consent. And the Obergefell versus Hodges case, which held that same-sex couples possess an equal protection right to marry, makes clear that both gay and lesbian conduct may not be criminalized or regulated differently than heterosexual conduct. So those two cases are big because you can see the evolvement on how things have changed over the years, specifically directed at consensual sex offenses and even, gay or lesbian conduct versus heterosexual conduct, and how one was criminalized and one wasn't, and how things have changed and evolved relating to those two things as well. Well, a couple of other terms, and then we're going to jump into gambling. So we're going to bigamy is the crime of marrying one person while still legally married to another. Polygamy is the state of having more than one wife or husband at the same time. And then incest is the unlawful sexual intercourse with a relative through blood or marriage. So basically sexual intercourse with a blood relative. So what about gambling? Let's take a few minutes and kind of jump into the phrase gambling, or gaming as it sometimes is called. So gambling is sometimes categorized under the heading of organized crime or vice offenses. And we treat it in this lecture as an offense against morality because it has all of the characteristics of such an offense, although it may also frequently be associated again with criminal activity. Now gambling can be defined as the wagering of money or some other thing of value on the outcome or occurrence of an event. Now, it is illegal where made so by law. And gambling is also sometimes called gaming in recognition of the fact that it may involve games of chance. And those are basically contests or events whose outcomes are determined, at least in part, by luck or by chance. So gambling, the wagering of money or some other thing of value on the outcome or occurrence of an event, also called gaming. And the laws in U.S. jurisdictions, they do vary considerably as what constitutes gambling. And we've seen a lot of evolvement in gambling or gaming as well. Places or things that were illegal are now legal, and the landscape there is kind of changing as well. States that have stringent anti-gaming laws generally also have statutes making it illegal to keep or own slot machines, or what they call punch boards, or gaming tables, or other gambling accoutrements, or things, or pieces. Now, in the state of Nevada, on the other hand, many games of chance like blackjack, poker, or shooting dice, if you will, are authorized, but they are strictly regulated and very much closely controlled. In a number of other jurisdictions, only state-run lotteries are permitted. And some states allow on-track participants to bet on dog and horse races, whereas other states, no gambling or lottery type of any kind is allowed. And they have some exceptions like church raffles or bingo games or fundraisers that are sponsored by, let's say, nonprofits. Now, under federal law, Native Americans are allowed to conduct games of chance on Indian reservations that are recognized by the U.S. government as independent jurisdictions, and you've seen a lot of these start to pop up. So, but as a general rule, it is pretty much fair to conclude that in most jurisdictions, any form of gambling not specifically authorized by statute is considered illegal, although state laws regulating gambling vary considerably. And just to mention really quick, as of late, there's been a recent case out of New Jersey on sports betting, where the Supreme Court, by a 6-3 vote, ruled in favor of New Jersey on sports betting. So now that has pretty much opened the door. I'm sure there's going to be quite a few regulations on this, but it's opened the door for other states to decide, because the states can make certain laws whether or not they're going to have gambling, sports betting, if you will. Okay, so that's, again, a recent Supreme Court case, I believe it was last month. So now let's move into controlled substances. So the word drug is a generic term applicable to a wide variety of substances. And just so you know, for this chapter, we're not going to delve into a lot of the super classifications of drugs and tell you all the differences between them all. We're going to touch on some legislation and a couple of the different controlled substances acts, if you will. So the word drug is a generic term applicable to a wide variety of substances that have any physical or psychotropic effect on the human body. And over the years, drugs have been defined by social convention, whereas today, for example, almost everyone would agree that heroin and cocaine, let's say, are drugs. They were not always seen as much. Now, similarly, although alcohol, nicotine, and even caffeine probably fall into a drug category in the minds of most people today, their categorization as drugs is relatively recent, having occurred during the past 2 or 3 decades. Now, both the law and social convention make strong distinctions between drugs that are socially acceptable and those that are not. Now, in your textbook on page 388, there's a table of drug terminology, and I'm not going to go through all these during the lecture. I'd like you to take a minute and go through all of those definitions. So, another important distinction can be made between 2 major classes of drugs. One, those that are biologically active, and 2, those that are psychologically active. And psychotropic substances, or drugs that affect the mind, are said to have psychoactive properties. And bioactive substances, on the other hand, are drugs that affect the body. Now, although bioactive drugs are subject to considerable regulation and control, most drug laws concern themselves with the manufacture, sale, and possession of psychoactive substances. So, a drug, any of a wide variety of substances having a physical or psychotropic or psychotropic, depending upon your definition, effect on the human body. And the two major classes for the text that we're going over today would be those that are biologically active and those that are psychologically active. Now, roughly 94% of federal inmates are serving time for drug offenses. And I have a link there that you can go to, and I guess I have a minute. Let me click there and see if I can get to the page just quickly so you can see it. And this will take you to the Federal Bureau of Prisons and talk about, there's a lot of different categories that you can look at if you want to look at inmate statistics. But one that kind of sticks out is if you look at this category right here, category E. And you can see the amount of people that are in custody. Now, I want you to go down to E, and I want you to see that it's drug offenses. Now, we're not talking about state custody. We're talking about federal, but look at the amount of people that are in there, 46.2%. So that should be concerning to you on why are there so many people in custody in federal prisons for drug offenses. And a couple of drugs to look at, just if you've never seen them, you know, we can look at a few of the big ones. In the upper left, you have what would be known as rock cocaine. In the top right, you have crystal meth. On the bottom left, you have heroin. It's brown heroin. On the bottom right, you have what we would call PCP or phencyclidine. Now, the term controlled substances, this refers to specifically defined bioactive or psychoactive chemical substances that have come under the purview of criminal law. And pharmacologists, chemists, and botanists are consistently discovering and creating new drugs. Street corner chemists in clandestine laboratories churn out an extensive amount of what we call designer drugs. These psychoactive substances with a widely varying, effects and abuse potential. And some of the new ones, just briefly to mention, would be on the top photo. You can see a picture of what they call spice, which is like synthetic marijuana almost. And then on the bottom, you have bath salts that are packaged usually in really cool looking containers or packages, and people are ingesting that, and it's a new thing that's happening, and the effects are extremely devastating. So in recent years, numerous federal and state laws have been enacted to combat the growing popularity of so-called date rape drugs like Rohypnol or GHB, and I gave you some pictures so you can see what they look like. Now, these are available on the black market and can leave victims who consume them either severely disoriented or unconscious for hours. And one of the side effects on these drugs is that whoever consumes them doesn't really remember what happened. So you could see that if somebody was the victim of a sexual assault, let's say, they wouldn't be able to recall all of the circumstances surrounding that particular assault. And then lastly, really quick before we jump into some legislation, would be again something new, which is nitrous oxide or NOS. And I've got some photos of a local law enforcement agency, the Rialto Police Department, that raided an auto shop in Fontana because this particular auto repair shop is selling NOS to kids, and they're having these NOS parties, and basically you put the gas into a balloon and then you inhale it. So again, there's a link on there that you can click and look at the news article on that. So let's jump into some legislation really quick as we're finishing up. The anti-drug legislation in the United States dates back to around 1875, when the city of San Francisco enacted a statute prohibiting the smoking of opium. And a number of Western states were quick to follow that city's lead. The San Francisco law and many laws that came after that, however, clearly targeted immigrants and were rarely applied to other ethnic groups that may have been involved in that same practice. Now, the first major piece of federal anti-drug legislation came in 1914 with the enactment of the Harrison Narcotics Act, and the Harrison Act required those dealing in opium, morphine, heroin, cocaine, and specified derivatives of those drugs were to register with the federal government and to pay a tax, an annual tax. And the only people permitted to register, however, were physicians, pharmacists, and members of the medical profession. Non-registered drug traffickers faced a maximum fine of $2,000 and up to 5 years in prison. Now, because of the Harrison Act, because the Harrison Act allowed physicians to prescribe controlled substances for the purpose of medical treatment, heroin addicts and other drug users could still legally purchase the drugs they needed. Now, by 1920, however, court rulings had established that drug maintenance, if you will, only prolonged addiction and did not quantify treatment. So the era of legally available heroin pretty much ended. Now, by the 1930s, government attention came to be riveted on marijuana, and in 1937, at the urging of the Federal Bureau of Narcotics, Congress passed the Marijuana Tax Act. And as the title of the law basically says, the Marijuana Tax Act placed a levy on cannabis at the rate of about $100 per ounce, and individuals who didn't pay the tax were subject to prosecution. So with the passage of the Boggs Act in 1951, however, marijuana, along with a number of other drugs, entered the class of federally prohibited controlled substance. And the Boggs Act also removed heroin from the list of medically useful substances, required the removal within 120 days after the Act's passage of any medicines containing heroin from pharmacies across the country. So things that maybe were available weren't available anymore. And now you have the Narcotic Control Act again, of 1956. So by 1970, well, let me back up. The Narcotic Control Act of 1956 increased penalties for drug trafficking and possession, and made the sale of heroin to anyone under the 18 a capital offense. Now, by the 1970s, America's drug problem was clear to almost everyone, and legislators assumed a highly punitive approach to controlling drug abuse. Under President Nixon, legislation designed to encompass all aspects of drug abuse and to permit federal intervention at all levels of use was enacted. So now in the 70s, we have the fight on drugs, the war on drugs, and this was termed the Comprehensive Drug Abuse Prevention and Control Act of 1970. And I have a link there that you can go to if you want to go to the DEA to look at the different categories of drugs. And what this did also, Title II of this legislation is what is referred to as the Controlled Substances Act. And this Controlled Substances Act set up 5 schedules that classify psychoactive drugs according to their degree of psychoactivity and the abuse potential. Now, I am going to go there really quick just so I can show you. And here is the DEA's website, and basically it talks about the different types of chemicals and drugs, and it sets up the drugs by schedule. So here you can see Schedule 1, and it gives you some examples, 2, 3, 4, 5. So you can go back and look at this, but you can see Schedule 1 drugs are substances or chemicals, are defined as drugs with no currently accepted medical use and a high potential for abuse. So those are just some examples of the definitions that they are using. But again, you can go to the website and you'll be able to see that. Now, because of each of the federal schedules depends primarily on a drug's abuse potential, it really is important to understand that whole concept. So we talked about different types of drugs that are being made, like designer drugs and things like that, and that's one of the other rationales for those specific categories. Now, on page 392 in your textbook, there is a federal drug legislation timeline that kind of walks you through a timeline of a lot of the different not only laws that were enacted, but some of the acts that we're talking about, like the Harrison Act or the Marijuana Tax Act or the Controlled Substances Act. You can see the timeline on which all those occurred. Now, in 1988, the Federal Anti-Drug Abuse Act was passed into law. And under this law, penalties for recreational drug users were substantially increased, and it became more difficult for suspected drug dealers to purchase weapons. The law also denied federal benefits to convicted drug offenders, ranging from loans, including student loans, to contracts and licenses. And the 1988 legislation also included the possibility of capital punishment for drug-related murders. So under this law, civil penalties up to $10,000 may be assessed against convicted recreational users for possession, even for a small amount of drugs. And again, it also included the possibility of capital punishment for murders. Now, along comes the Crime Control Act of 1990, and this basically doubled the appropriations authorized for drug law enforcement grants to states and local communities, and it enhanced drug control and education programs aimed at the nation's schools. It also expanded specific drug enforcement assistance to rural areas, rural states, and expanded regulation of precursor chemicals used in the manufacturing of illegal drugs. Because think about it, as people got a lot smarter on what makes up a certain drug, especially if it was a synthetic type drug, they would come up with different chemicals to make the drugs, and these chemicals that were used to make the drugs are called precursors. So sometimes it was illegal to have the finished product, but it wasn't illegal to have the chemicals that made up that product, if that makes sense. So this expanded the regulation on precursor chemicals that were used to manufacture that. So that's a good thing. So it sanctioned anabolic steroids under the Controlled Substances Act. It included provisions to enhance control over international money laundering. It created drug-free school zones by enhancing penalties for drug offenses occurring in close proximity to schools, and enhanced the ability of federal agents to basically seize property used in drug transactions or purchased with drug proceeds. It provided the Violent Crime Control Act and Law Enforcement Act of 1994 also provided $245 million for rural anti-crime and anti-drug efforts. It set aside $1.6 billion for direct funding to localities for anti-crime efforts, and budgeted $383 million for drug treatment programs for state and federal prisoners. It also created a treatment schedule for all drug-addicted federal prisoners and required post-conviction drug testing of all federal prisoners upon release. It allocated $1 billion for drug court programs for non-violent offenders with substance abuse problems, and mandated new stiff penalties for drug crimes committed by gangs. And the act also tripled penalties for using children to deal drugs near schools and playgrounds, and enhanced penalties for drug dealing, again, in those drug-free zones near playgrounds, schoolyards, video arcades, or youth centers. It also expanded the federal death penalty to include offenders involved in large-scale drug trafficking, and mandated life imprisonment for criminals convicted of 3 violent felonies or drug offenses. And state-level anti-drug laws, there is a surprising degree of uniformity. Let's look at a couple points. Other than possession, jurisdictions generally criminalize the manufacture, sale, and purchase of a controlled substance, and most states have also created special penalties for adults who sell drugs to juveniles, and for adults, again, who employ juveniles in the illegal drug trade. Asset forfeiture statutes find a legal basis in the relation-backed doctrine, which assumes that because the government's right to elicit proceeds relates back to the time they are generated, anything acquired through the expenditure of those proceeds also belongs to the government. So if you don't know what asset forfeiture means, that basically means that those proceeds, things that are made or acquired through the use of drug trafficking, drug sales, manufacturing, etc., law enforcement agencies can seize a lot of that information, or a lot of that stuff. So let me give you the actual definition. Forfeiture is an enforcement strategy supported by federal statutes and some state laws that authorize judges to seize all monies, negotiable instruments, securities, or other things of value furnished or intended to be furnished by any person in exchange for a controlled substance. All proceeds traceable to such exchange. So that gives the government the ability to seize a lot of those proceeds. Now, one last term to know before we finish would be the RICO statute. And this is a section of the Federal Organized Crime Control Act. It's known as the Racketeer Influenced and Corrupt Organization Provision. And it also authorizes forfeiture as a criminal sanction, and both were passed in 1970. Now, finally, medical marijuana. Now, in addition to over 20 states that permit marijuana as a form of medical treatment, several jurisdictions have decriminalized the use of small amounts of marijuana, including Colorado, Oregon, Washington, and Washington, D.C. Now, since the writing of this text, there have been other states that are decriminalizing the recreational use of marijuana, including, of course, California, which was Prop 64 in 2016, where 57.13% voted for it and 42.87% voted against it, and therefore we have medical marijuana applicable with regulation in the state of California. So I know that was a quick overview over a lot of these different laws and things relating to morality and public offenses, etc. But I wanted to make sure that we got everything in. So sorry it took a little bit over the 60-minute mark, but we did make it. So with that being said, make sure that you look at the summary at the end of the chapter, and also don't forget, okay, it's very helpful to go through all of the definitions there so you can get a better understanding and add some context to the lecture as well. So with that being said, that will conclude our chapter 11 lecture. Until next time.